Hitchcock Cross talking to you today. We've got a response here from Judge Molitor on the motions that the county and Mr. Lucky filed against each other for apparent discovery violations. Again, we believe that the county purposely withheld documents from Mr. Lucky in discovery that were particularly damaging, especially these records from the Human Resources Department, the notes and apparent videos that they have. So we'll go see what Judge Lawrence has to say. Judge Molitor has to say. Lawrence is the opposing counsel. So we'll do that. Let's go. And thank you very much, everybody who's watched that video, especially number 4 on Lucky. I really appreciate your time and your thoughts. So, here it is, state of Wisconsin. Yours truly, Melinda Lawrence. All right. James Lucky, dear counsel. On August 27th, 2021, the Equal Rights Division received a discrimination complaint from the complainant, James Lucky, signed August 24th. In that complaint, Mr. Lucky stated that he was discriminated by the respondent, the county sheriff's department, on the basis of race, color, and sex because he opposed discrimination in the workplace. All right. Following an investigation, it was decided that no probable cause to believe that the county discriminated against Mr. Lucky in terms of conditions of employment because of color, race, or sex because he opposed discrimination practice. Mr. Lucky appealed the matter, was certified to hearing on the issue of probable cause on January 31st, 2022. The parties could begin discovery as of that date. So it's also important to note that the county walked out Mr. Lucky and then eventually terminated him while this investigation was going. And the investigator refused to help Mr. Lucky amend the complaint, instead told him to file a new complaint, but only when they terminated him. And then they terminated him. He said that to them, and then she issued the no probable cause. So that was disappointing. I think it was Michelle. Well, I don't want to say if I don't know, so I won't. Okay, at a pre-hearing conference in this matter, and just so you know, when it says that discovery could begin as of that date, that's going to be a dig against me for getting in discovery at the last possible moment. Okay. At pre-hearing discovery conference in this matter, the deadline for completing discovery was established, December 16th. It's my understanding that on November 15th, 1 month and 1 day before the discovery deadline, the complainant faxed to the respondent 150 requests to admit, 23 requests to produce, and 7 interrogatories. It is my understanding that the respondent answered the complainant's discovery request on 6th, 20th, and 31st, and January 6th. Okay, so it really doesn't matter if we did it on any day after 1 month and 1 day, if we did it on 1 month and 2 days, on 1 month and 30 seconds, on any of those days, doesn't matter. That's before the deadline. So let's just be clear that we filed it before the deadline. That's what that means, is to be clear to say. And then they responded after the deadline. December 1st is before. December 20th was after. December 31st is after. And January 6th is after. Okay? So let's just be clear. At the final pre-hearing conference, it was clarified the complainant's termination was not at issue. The complainant requested the matter be sent back to the Equal Rights Officer for further investigation. That request was denied because the complainant could not amend his discrimination complaint to include termination. The termination based on different later set of facts should have been the subject of a new complaint. See, again, that's not what the actual law says. She doesn't say why that's the case. That's not great. There's no law underpinning that decision there. So that's what I'm complaining about there, I would say. So, because the complainant could not amend his discrimination complaint to include termination, that's what you call circular reasoning. The complainant could not amend his discrimination complaint to include determination because the complainant could not amend his discrimination complaint to include termination. And it's determination based on a different set of facts. That's not an evidence there, and I would say that's just wrong. In fact, it's the exact same set of facts. So that's just completely wrong. Should have been the subject of a new complaint. But if that's the law, that's good to know, but that's factually that decision is wrong. There's no reason to say that There's a new set of facts. There's nothing in the previous statements there. I also want to say, as far as I understand, Judge Molitor's probably issued very few of these, and this may be one of her more recent, let's say, new attempts at writing this. She may have written hundreds of decisions, I just don't know, but based on my understanding of where she's at in her ERD training and so forth, I believe she's fairly new at this. I'm not, let's say I have seen ALJs with much more extensive experience do a much worse job at that, so I don't want to sound negative at all. This is not an attack on her as a person at all. And again, I feel like she's come a lot further than many ALJs here in a very short period of time. And I think if you compare her to Stephanie Brown, for example, there is a much better willingness to follow the law and to admit when there's a mistake that's been made, or let's say that there's an opportunity for growth, or even to say there's an opportunity to get it right. So I've seen many ALJs refuse to take that opportunity to get it right, and we'll show them for you here. But again, I think that's that's something that I want to compliment her on and say that I think she's trying here, but at the same time we're going to criticize. So I think we can do all that at the same time here. Okay. At the final pre-hearing conference, all right, so the termination based on a different set of facts should have been the subject of a new complaint. Again, assumes facts that I didn't see. The hearing, and to be clear, the minimum of what a judge has to do is basically set out the facts upon which they base their decision. So that part's important. They don't have to show each individual fact, but there has to be some basis in the record for them to state that this is so. I'm making this decision because of this fact. And then they need to have some rule to go with that fact. And so that's those two things. They have to show their analysis. That's what a judge does, is to analyze the law with the facts and make a decision, and then they have to write out their decision. So that's really the standard. That's what due process is, and that's the only standard that we're looking at this right now. The hearing in this matter was scheduled for 3 days, the 24th, the 25th, the 26th of January. On the third day of the hearing, it came to light that the Milwaukee County Human Resources business partner, Mary Paul, had in her possession personal notes that she had created that documented her interactions with the complainant in August 2021 concerning him not feeling safe at work after having an interaction with Sergeant Fred Gladney regarding something union-related. I don't know about this regarding something union-related. I do know that came straight out of, this is a sort of a sky is green moment. So Miss Paul didn't say it was union-related. Who said it was union-related? This is problematic. Was straight up Melinda Lawrence. What's problematic with that is the attorneys, we are advocates. We argue, we don't give evidence. So if, again, the words union-related are coming straight out of Melinda Lawrence's mouth and not out of Mary Paul's mouth, that's a big problem. That's a big problem. Ms. Paul documented that she spoke to the complainant on August 18th via Teams about leave options and received from him on August 29th, 2021, a written copy of the complaint he had filed with Internal Affairs about the Gladney incident. And see, this is also just wrong, factually wrong. It's very clear that he's talking about the retaliation at work and not feeling safe. This is not okay. A written copy of the complaint he had filed with Internal Affairs about Ms. Paul testified that she did not start an investigation into the complainant's complaint because he had submitted the same complaint to an Internal Affairs and it was already the subject of an investigation. See, that's false. She didn't testify to that at all. She testified that there was a decision made that Internal Affairs was going to investigate it and she wasn't, and that she didn't tell Mr. Lucky that. So, no, didn't happen. I mean, you all have seen the video, but you tell me where it says that she said that she did not start an investigation into the complainant's complaint because he had submitted the same complaint to Internal Affairs and it was already the subject of an investigation. Because everything I heard was that he refused to keep going to Internal Affairs because he was getting discriminated against, so he went to HR instead. Because every time he got retaliated against when he went to Internal Affairs. I didn't hear that once. Sorry, but didn't hear it. Ms. Paul's personal notes had not been turned over to the complainant as part of the pre-hearing discovery process. The complainant's attorney, yours truly, requested sanctions, including default, adverse ruling costs, and attorney's fees. The respondent's attorney, Lawrence, objected to the relevance of Ms. Paul's notes and to yours truly's representations that the failure to provide them was a discovery violation. I ruled that the hearing should continue and the party should brief the issue of sanctions. I also ruled that Mr. Lucky could engage in further discovery to the extent that the respondent's failure to produce documentation regarding Mr. Lucky's internal discrimination complaint with Human Resources induced Mr. Lucky to forego further discovery. Witnesses could be recalled as necessary. After my ruling, didn't say that. Didn't say anything about witnesses could be recalled as necessary. Didn't say it. It did say the part in italics there. It didn't say witnesses could be recalled as necessary. After my ruling, the parties disagree on the scope of discovery that could take place. So, in fact, I subpoenaed people for depositions, and they refused and didn't appear. That's what happened, to be clear about discovery. And then she clarified, again, within nanoseconds, that she intended the scope was to be narrow and said that there would be no discovery. So, so again, the judge can pick different facts that support a different position than one that I have. That's perfectly legitimate here. Again, the issue is that we can't say facts that aren't in the record. That's problematic. That's not due process. So witnesses could be recalled as necessary. And again, we tried to call witnesses, but then they didn't show up. They refused to show up, and then the judge tried to get Mr. Lucky to testify and told us that it was her preference that Mr. Lucky would testify. So that's the whole tenor of that. I don't agree with much of that statement being in the record there. Okay. Argues that the county failed to produce discovery, made false statements to the tribunal about that failure. And see, there was a statement in there that they didn't put in, which is very important, that Ms. Paul testified that she gave these documents to Ms. Lawrence in the spring of 2022. Argues that was prejudice the county's failure to produce documents in the form, describing the form of documents in the form of video recovery's team meeting between Ms. Paul and others. Further argues that the failure to award damages to allow the county to rough roughshod over Mr. Lucky's rights and the authority of the tribunal. That sounds pretty accurate. Attorney Lawrence argues that Mr. Lucky did not make a request that could be reasonably be interpreted to have encompassed Ms. Paul's notes. So she doesn't put that in there, because they are not statements regarding Mr. Lucky's employments. They sure as heck are. Because the notes do not concern the terms and conditions of Mr. Lucky's employment. Well, because of course they do. The notes are not related to any defense or internal defense. They are. Absolutely. We're trying to say that, and their affirmative defense is that they investigated and properly dealt with these complaints, and we're trying to show that they didn't, and these notes show that. And our materials related to Lucky's fitness, okay, are not encompassed by audio documents and evidence, resolve any of the complainant's complaints while employed. Well, but so that's just couldn't be, okay, but hey. Because the request was too vague and non-specific, Tony Lawrence noted the county's response to this request that it was too vague and confusing, and cited to Mr. Lucky's failure to identify particular complaints at issue. Attorney Lawrence noted that Mr. Lucky did not address the county's objection to the request at any time prior to the hearing and argues that there is no basis for the imposition of sanctions in this case because any violation of discovery rules would have been inadvertent at most, and any prejudice to the late discovery of Ms. Paul's notes may have caused Mr. Lucky has been ameliorated by my rulings in this matter. So again, we get to call additional witnesses and pay money, but we have to pay to have me spend my time recalling these witnesses. That's really what's at issue here, is who has to pay to undo what they did by hiding these documents. Okay? That's the first question. Attorney requested for default is frivolous because the county did not engage in egregious conduct or bad faith without a clear and justifiable excuse. Attorney Lawrence argues that Mr. Lucky's request for an adverse instruction against the county is frivolous because it is Mr. Lucky who seeks to introduce evidence concerning his contact with Ms. Paul, not the county. Finally, Attorney Lawrence argues that Mr. Lucky's demand for costs and fees is frivolous and to award them would be unjust because 1, the county did not violate any discovery rule, and 2, the admitted information is of no probative value to the issue before the tribunal, and 3, the relative cost of discovery outweighs the remedy sought by Mr. Lucky. All right, findings regarding sanctions. Default judgment is appropriate sanction for discovery violations in the non-complying party's conduct is without a clear and justifiable excuse and either egregious or in bad faith. Egregious conduct is conduct that, although unintentional, is extreme, substantial, and persistent. I find that the respondent's failure to discover and turn over Ms. Paul's notes was done with a clear and justifiable excuse. Oh, okay. Mr. Lucky's complaint to the ERD predated the complaint he provided Ms. Paul, and Mr. Lucky did not indicate in his complaint that the ERD, see, that's, where is that in here? Received from him on August 29th. He signed August 24th. Okay, got it. She got that part in there. Well, part of the problem with that is that they gave us documents that relate to that HR stuff up and down. They just didn't give us those documents. So that's problematic, but okay. I also find it was not in bad faith or egregious. The respondents attempted to respond in full, I believe it had, and believed it had, to the complainant's discovery request. The respondents did not intentionally delay or obstruct the complainant's discovery demand. I guess you'll have to make that decision for yourself, and its conduct in missing Miss Paul's notes was not so extreme, substantial, and persistent that it can probably be characterized as egregious. So again, the fact that they had the notes and chose not to give them, that's the key issue here. Whether they're relevant to the complaint, whether they were asked for, they were, she didn't say that, and then whether they didn't give it to us. And then the question is, do they do it intentionally? And apparently it's our fault because he had identified other staff members in human resources. So it's our fault because although we asked for all documents related to his employment and notes regarding his complaints and responding to his complaints, this is a complaint that he filed. It's our fault for not being being specific or too specific or something else. And again, they had these documents. They just chose not to give them to us. I further find that other sanctions are not warranted. There is no indication that respondent's failure to produce Ms. Paul's notes was the result of wrongful conduct. No pattern of avoidance, delay, or disregard of the respondent's obligations under the discovery statutes is evident. Most importantly, even if the complainant would have received Ms. Paul's notes when he received the other documents in answer to his discovery request, there simply was insufficient time for him to pursue discovery from the respondent by way of depositions or additional requests for information. When I stated that Mr. Lucky could engage in further discovery to the extent that the respondent's failure to produce discovery documents regarding to Mr. Lucky's internal discrimination complaints with human resources induced Mr. Lucky to forego further discovery, I was unaware that based on the timing of his original discovery request, Mr. Lucky was not in a position to conduct further discovery. See, the problem with that is we could have requested further discovery. She could have easily granted an extension. Therefore, he was not induced to forgo further discovery by the respondent's failure to produce the information at issue, as he lacked time to conduct any further discovery. See, that's up to her. It's absolutely the case. They didn't give us documents until after the discovery period had ended. What, we don't get to respond to those? Even if there's, I mean, that's, of course not. Of course not. But this is blaming Mr. Lucky for their failures in an attempt to to deny the fact that it's egregious here. Again, they knew that they had these documents, that Ms. Paul gave these documents to the Corporation Counsel's office. That's not in there at all. Okay? They say that she says that there's other issues that are around, but that doesn't respond to the fact that they gave us other documents from Ms. Paul, including the complaint that he wrote to her. They just didn't give us her notes, even though we asked for them. Because the notes show that she was talking to Molly Zillig, who Molly Zillig said that she didn't talk to her at all and can't remember any of these conversations. That's what the problem is. And again, we could have asked for more discovery. We could have said, hey, Judge, this is a problem. She is purposely putting a false deadline there on us and then saying it's your fault because although you got it in on time, it could have been more on time. We're not going to deal with the fact that what their response was because you could have answered it earlier. Well, that's not what the issue was at all. The issue was, and what the law is on that was, did they fail to produce this information on purpose? And there's no analysis of that whatsoever. She decides that they didn't do it on purpose. Was done with a clear and justifiable excuse. Okay. So again, the complaint predated the complaint, but we have all this stuff from Ms. Paul, so I don't know where they get that concept from. He did not indicate in his complaint with the ERD that he went to the Human Resources in any other year than 2019. They know that because he went to their, oh my God, it's their Human Resources that he went to. They have these documents, they just didn't turn them over. I also find the respondent's conduct was bad faith, attempted to respond in full and believe that it had. How do you know that? On what basis do you say that? The respondent attempted to respond in full and believe that it had to the complainant's discovery request. This is the testimony of Melinda Lawrence. That's what that is. That's a significant problem. That's a significant problem. Who else? You go look at the recording. Who else but Melinda Lawrence said the respondent did not intentionally delay, obstruct, or refuse the complainant's discovery demand, and its conduct in missing Miss Paul's notes was not so extreme, substantial, and persistent. And who said that? Who said that? Other than Miss Lawrence. Well, now we got a problem. Because Miss Lawrence, again, can't be the witness and the advocate. So we're going to have to deal with that. All right. Complainant's motion for costs and fees for the respondents is denied. Ms. Zilligan were not subpoenaed to appear on March 6th, and the argument that they were under a continuing subpoena from the January hearing is unavailing. the complainant's motion to compel production of video recordings of meetings on August 18th. See, again, we subpoenaed them. She told us we couldn't have discovery. And then if you look up here, remember how she added this thing where it says, Mr. Lucky's internal discretion, to the extent that respondents' failure to produce documents regarding Mr. Lucky's internal discrimination complaints with human resources go further discovery, witnesses could be recalled as necessary. Okay, the argument that they were under a continuing subpoena from the January hearing is unavailing. Why? Under what law? Where do you get that from? The complainant's motion to compel production of the video recordings of the teens meeting on August 18th, in which Ms. Paul discussed the complainant if such recordings exist, is granted. If such recordings do not exist, an affidavit to that fact is sufficient to establish the same. I recognize that not all teams meetings are recorded. The burden of providing the complainant with these recordings, if they exist, is not unduly burdensome. That gives them a pretty easy out, doesn't it? The complainant's motion for a default judgment, as well as costs and fees for the respondent's refusal to confer regarding post-hearing discovery disputes broadly and for failing to provide Ms. Zillig for deposition specifically, is denied. The respondents conferred with the complainant via email. No, they, under absolutely no circumstances could you call it that. And it was clear that the parties were not able to resolve their discovery disputes on their own. With respect to the failure to produce a witness for deposition, the complainant may not depose a witness now who he could have but did not depose during the discovery period. That's circular logic, to say the least. I couldn't depose somebody because I didn't depose them. Okay, it's this statement here. The parties were not able to resolve their discovery dispute on their own. Okay. What does that mean? That doesn't mean that they're, whatever they say, they're refusing to produce discovery or refusing to, the discovery being deficient, or they're refusing to have depositions. Oh, because we discussed it, so therefore there's no problem? That doesn't make any sense at all. There's no law there. It's just... I'm kind of shocked. 5 additional days have been set aside for this hearing. The complainant is allotted 3 of those additional 8-hour days, 23rd, 23rd, and 24th, to present his case, including the complainant's testimony and cross-examination. The last 2 days, 25th and 26th, are reserved for the respondent to present its case. Be cognizant of the timeliness and plan your cases accordingly. The parties are expected to work together to coordinate the appearance of witnesses to be called adversely by the complainant. Unless the attorney for the respondent agrees to be accepted service, new subpoenas will need to be issued and served. No open-ended multi-day subpoenas will be enforced. Likewise, the parties are expected to work together. If the complainant plans to recall witnesses to testify, that's not working together. That's not working together. To coordinate the appearance of witness fees to be called adversely by the complainant. Unless the attorney for the respondent agrees to accept service, new subpoenas will need to be issued and served. No open-ended multi-day subpoenas will be enforced. This okay. Likewise, the parties are expected to work together if the complainant plans to recall witnesses to testify regarding their interactions with Ms. Paul regarding the complainant, for example, Ms. Zillig or Mr. Novotny. I do not believe that other witnesses who have testified have relevant testimony to offer based on the limited scope of my ruling concerning Ms. Paul's notes. In closing, I note that many of the problems in this case could have been avoided had pre-hearing discovery been done, including depositions well in advance of the discovery deadline. I have done my best to address everything raised by the party. In the event that I have failed to address any motions from either party, such motions are denied. Ann Marie Molitor. Well, there's room for improvement. There's room for improvement. And of course, Mr. Lucky's got to cram it. They get to hide documents. They will continue to hide documents. That's what this means. They are going to continue to withhold documents, relevant ones, unless they get caught. Continue to get caught. That's what's going to happen here. There's absolutely no doubt about it. They refuse to produce documents. They refused to produce documents a second time. They haven't followed the rules on discovery. They haven't followed the rules on conference. There's one rule for them, and there's another rule for Mr. Lucky. And it's kind of shocking. It's kind of shocking. Stick with us. We'll keep you informed.